And, of course, we want new business creation for many reasons. We want innovation. We want lower prices. Competition brings prices down in markets that operate well, but also new businesses create jobs, right? A lot of the job creation that occurs in our economy is because entrepreneurs try something. They bring on their cousins, their in-laws, they bring on their neighbors, they bring on people from the community, they hire experts, and as they build and build and build and build, the economy is vibrant, it's dynamic. So this is a dynamism rule as much as it is a free competition, fair competition rule. So higher wages, more competition, lower prices, better healthcare. I'm against it.
What's not to like?
Sorry, you talked me out of it. Okay. Hello, powerful people, and welcome back to the Power at Work blog. My name is Seth Harris. I'm a senior fellow at the Burns Center for Social Change. We are calling this a breaking news blogcast, and that's because yesterday, which was Tuesday, April 23rd, was a very, very important day for workers in the United States. The Federal Trade Commission issued a final rule prohibiting employers from including non-compete clauses in their employment agreements with their workers. The vote was 3-2. That's enough for the FTC to act. Let me just refresh the audience's memory that employers use non-compete agreements essentially to stop, not essentially, in fact, to stop workers from quitting their jobs. They can't go to work for employers' competitors. They can't start a competing business. And, if you can't continue in your occupation, in your industry, you probably can't quit your job unless you want to make a radical change in your life. So as a consequence of that, non-competes are really a pure restraint of trade, a pure restraint of competition. And by definition, that makes them anti-competitive. They're also extremely bad for workers. And we're going to talk about that with a very special guest today. Now, the commission was urged to take this action by President Biden in an executive order that he issued in July 2021. But unions and worker advocates and progressive antitrust scholars have been calling for this action for even longer than that. Want to give the president credit, but want to give the advocates their due. They were the reason that this got taken up in the first place. Helps that the chair of the FTC is actually one of those advocates. But this is, let's be honest, this is the FTC operating in a new space. The final rule is almost certainly, I could probably take the word almost out of that sentence, going to face a legal challenge or 2 or 10 or 20. The regulation is scheduled to take effect 120 days after our guest and her colleagues get it published in the Federal Register with big, complicated rules that can take days. It can also take a couple of weeks, but it won't take a lot longer than that. So if everything goes according to plan, and it definitely won't, the rules should be in effect in the next 4.5, 5 months, and then the lawsuits will begin. To help us understand this groundbreaking, extremely important regulation, I brought you a good friend of mine. She's also a former co-worker of mine. We worked together in the White House at the National Economic Council. Hannah Garden-Monheit is the director of the Federal Trade Commission's Office of Policy Planning. We met when she was a special assistant at the National Economic Council in the White House. Hannah worked with me on a whole bunch of labor issues, but she also worked on competition issues with a really extraordinary, I think you'd agree with this, an extraordinary team of competition scholars, lawyers, advocates, antitrust experts. It was really something. So she left the White House last November to join the FTC team led by FTC Chair Lina Khan, to help her to get this regulation out the door. And now she has done that. That's why she has a smile on her face, because this big piece of business is off her desk and it is out into the public and almost in the Federal Register. Hannah is an elite lawyer. She's an elite public policy professional. She's worked at a private law firm in a Supreme Court and appellate practice. She worked for the Justice Department. She clerked for the Deputy Supreme Court, the U.S. Court of Appeals for the District of Columbia. So she's really just terrific. I'm a huge fan of hers, as you can tell. I could keep going, Hannah. Maybe the whole broadcast is just me praising you, but I think we want to talk about non-competes. But Hannah Garden-Monheit, so great to have you here on the Power at Work blog.
Seth, thank you so much for having me. It's such a pleasure and an honor to be here on this momentous occasion.
Yeah, it's really exciting. So here's how exciting I think it is. And I've said this in a bunch of venues. I actually said it in a radio interview just a few hours ago. I think this rule is the most important labor regulation in the Biden-Harris administration's first term. So I want you to help us to understand why it is so important. So let's start at the very beginning. What does the final rule prohibit? And will any non-compete agreements still be in effect if this rule is able to take final effect?
Sure. So the rule bans non-compete clauses, which are agreements really a misnomer here, clauses imposed on workers that prohibit you from working for a competitor or starting a competing business. And the rule does three things. First, it prohibits employers from entering into new non-compete agreements with any workers, including senior executives, as of the effective date. As you said, that effective date is 120 days from publication in the Federal Register. We estimate that'll be about early September. Second, the rule prohibits employers from enforcing non-competes after the effective date with workers other than senior executives. So existing non-competes with senior executives can remain in force, but no new non-competes with them or anyone else. And after the effective date, you can't enforce existing non-competes for workers other than senior executives. And then third, the rule requires employers to give notice to those workers other than senior executives that their non-competes are no longer enforceable. And it's important to recognize here, senior executives is a very small slice of the population as defined in the rule. We're talking about 0.75% of US workers. The rule also applies to the full extent of the FTC's jurisdiction. That means it covers about 80% of the US workforce.
So let's just clarify that. So the folks who are not covered by this rule, who will not benefit from this rule, are employees of not-for-profit organizations, because if I understand it correctly, the FTC doesn't have jurisdiction over not-for-profits, and the public sector also is not affected by this, right? So state and local governments, if they have not non-compete agreements, the FTC is not able to reach them. Do I have that right?
I believe our jurisdiction, there's some question about the particulars on the public sector. The rule changes nothing about our existing jurisdiction on that respect. On nonprofits, a little clarification there I think is important. You are right that our jurisdiction doesn't cover true nonprofits, but it's important to recognize that whether you're covered or not is not the same thing as whether you claim tax-exempt status with the IRS. Our jurisdiction is under Section 4 is whether you operate for the profit of your members. And of course, whether or not you are doing that is not necessarily the same thing as whether you are claiming that on your tax filings. And that is something
Right.
that
So like a trade
commission...
association that's helping, right. So trade association is helping its members to make money in some way might be covered by this rule in a way that, a not-for-profit think tank would not be covered by the rule.
Exactly. And the rule doesn't change anything about our jurisdiction. That is our existing case law and precedents around how our jurisdiction over nonprofits operates. And the preamble of the rule lays out some of that case law.
Yeah. Let me just say that all across America, there are now public sector employers calling their lawyers saying, Hannah Garden-Monheit just said, and now they're going to have to figure out whether or not they're covered. Let me just say that's something that they need to start thinking about. There's also, help us to understand the senior executive. Is that a dollar threshold? Is that a job function threshold? Do you have to be a CEO? Do you have to be a C-suite? Is it, I know that I saw $151,000 in change as sort of a dollar threshold, but is there more to it than that?
So there are two prongs. The answer is both. There is a dollar threshold, that's the $151,000 and some change. And then there is also a job duties test. On that job duties test, it's whether you have policy-making authority for the organization as a whole. If you're the CEO or the president, you don't have to resort to that job duties test, you automatically meet it.
Good. Okay, so I want to sort of turn that question around a little bit. Are there any legitimate interests for employers? Let me put it another way: a legitimate employer interest that non-compete agreements protect, or did you find that in every case where folks were talking about, oh, you got to protect trade secrets or you got to protect proprietary information, that there are alternative tools to non-compete agreements available to employers to protect those interests?
It's exactly the latter, Seth. What the commission finds is that there are less restrictive alternatives that are available to employers to use to protect their legitimate investments, whether that's in intellectual property or training of workers, things like NDAs, which the commission also finds about 95% of workers with a non-compete already have an NDA. So there are bodies of...
NDA meaning non-disclosure agreement.
Yes, non-disclosure agreement. So there are bodies of law that exist for the purpose of protecting intellectual property. Those are less restrictive alternatives that employers have available. You can, of course, also always compete on the merits to retain your workers. You don't have to trap them with a non-compete. You can offer them better pay, better benefits, better job quality.
How about that?
Yeah.
How about that? Actually keeping workers by paying them more money, giving them better working conditions, and showing them a career ladder inside the organization. It's a very novel idea.
Indeed.
We're going to have to think about that one.
I'll also note the rule only applies to post-employment restrictions, right? So if you and a worker bargain over a fixed term of employment, right, you can retain somebody for the period that you need to recoup whatever investment in training. And that is something that you can do on the front end by negotiating a term of employment that makes sense for both workers and employers.
Yeah, absolutely.
You can stay up to date with the latest news about workers, worker power, and unions by subscribing to the Power at Work blog. You'll receive the weekly download, a Power at Work newsletter sent straight to your inbox. The weekly download collects about 24 of the week's articles, academic studies, press releases, podcasts, and videos from across the internet. We find the stories and deliver them directly to you. So subscribe to the weekly download right now on the front page of the Power at Work blog. Go to poweratwork.us.
So I wrote about this issue on the blog when the FTC proposed the non-compete rule quite some time ago. It was very early in the life of the blog. But I want to remind the audience about sort of what the scope of this rule is going to be, or more precisely, what the scope of non-compete agreements are, because I think the popular assumption is, well, this is senior executives and this is scientists and this is technology folks in Silicon Valley. It's very specially skilled people who know the secret sauce or the secret algorithm, and it's just employers trying to protect that knowledge. If I remember correctly, and I'm hoping you're going to correct me if I get this wrong, the commission estimated, at least originally, that 30 million Americans, which is a little less than 1 in 5 workers in America, is subject to a non-compete agreement. If I have that right, what is it going to mean for those workers and for the economy as a whole when this rule takes effect and employers are not able to impose non-compete agreements on employees anymore?
Yeah, so you have that exactly right. The commission finds that about 1 in 5 workers, 30 million workers, are subject to non-competes currently. And what this rule is going to do by promoting competition in labor markets, one thing that it'll do is increase workers' wages, right? Lack of competition trapping you in your job suppresses wages because you can't negotiate for a raise, you can't leave for a competitor when you have a better offer. And what the commission estimates is that it's going to increase wages by about $524 for the average worker a year. That really adds up. It adds up to about $400 billion over the next decade in increased wages.
That's billion. I want you to enunciate. That's billion with a B.
Billion with
almost
a B.
Half. Actually, 400 billion. If I understand what you publicly put out, is the low estimate. some of the estimates get almost up to $500 billion in wage increases for workers over the course of 10 years. All across America, again, I could hear workers raising their hands saying, okay, I'll take it. I'll take it. 500 something dollars per worker per year. Pretty amazing. So, but it's not just, actually, let me just spend a minute, because you and
Yeah.
I know you and I talked about this back in the day. One of the fascinating things about the American economy is, because we are such a low union density economy, is that workers have a lot of trouble bargaining for better working conditions and wages with their current employer, because they don't have very much power with their current employer. So the way American workers exercise power is to threaten to quit or to actually quit. And there was a study done by, I believe it was the Federal Reserve Bank of Atlanta, that analyzed whether workers got bigger raises by quitting and going to a new job, or staying in their current job and negotiating with their current employer. And of course, the people who quit did better. They did much better, because that's where worker power is for individual workers in America. And that's why that those whopping wage numbers that you're talking about for those 30 million workers, and let me also say for other workers as well, because if you have to raise wages for the workers who are quitting their jobs, you're going to have to raise wages for the incumbents in those jobs as well. So it's going to drive a nice, solid wage increase.
And
Don't
Seth,
tell the Federal Reserve. Go ahead.
if I might add it, not just the workers at those employers who have non-competes imposed on them, what the commission finds from the empirical literature is that the suppression of wages also affects workers who aren't subject to non-competes. It has these spillover effects from the suppression of competition in labor markets in the aggregate that we see affecting people even who don't have a non-compete themselves.
Yeah. So it's not just workers, though, right? It's not just work and wages and working conditions. One of the, it's funny when I find myself advocating on behalf of capitalism to employers who are supposed to be guardians of capitalism. But if I understand how capitalism is supposed to work, competition is supposed to encourage innovation, right? You're supposed to compete by doing things in a new way, in a different way, by appealing to customers in a different way, not by locking people in to their jobs. So I talk a little bit about what this rule is going to mean for entrepreneurship and for innovation in our economy.
Sure. So the commission estimates that the rule is going to lead to the creation of over 8,500 new businesses every year, as well as between 17,000 and 29,000 more patents each year. And there are a couple of different mechanisms by which non-competes stifle that innovation and new business formation. So one piece of this is the friction imposed on the free functioning of competition in the labor markets, right? When you have a non-compete, not only can the worker not go find the best job for them, but employers also can't find the best worker for the job, right? They may be tied up by a non-compete, right? And that reduces the efficiency and productivity of the firm. So that is one mechanism. Another mechanism is that new business formation, in the direct sense, right? The non-compete prevents the worker who has an innovative new idea from going and starting a new business or a competing business, right? We had comments from folks like one really jumped out to me, an asphalt worker in Michigan who said, I could start a company that does this cheaper. I want to start my own business, but a non-compete trapped me. Another one from somebody who works for a power washing company who says, I want to start a competing power washing company that offers lower prices to consumers. I can't do that because I'm trapped by a non-compete. This ultimately has effects on consumer prices. The commission estimates that in healthcare markets, the rule will lower healthcare costs by as much as $200 billion over the next decade.
Remarkable. And, of course, we want new business creation for many reasons. We want innovation. We want lower prices. Competition brings prices down in markets that operate well, but also new businesses create jobs, right? A lot of the job creation that occurs in our economy is because entrepreneurs try something, they bring on their their cousins, their in-laws, they bring on their neighbors, they bring on people from the community, they hire experts, and as they build and build and build and build, the economy is vibrant, it's dynamic. So this is a dynamism rule as much as it is a free competition, fair competition rule. So higher wages, more competition, lower prices, better healthcare. I'm
What's
against
not
it.
to like? What's not to
Sorry,
like?
you talked me out of it. Okay, I wanna. So now I'm going to get to some of the more sensitive stuff, some of the more challenging stuff. So I want to talk, and by that I mean let's talk about the law. Most people don't ever think about antitrust law. They don't think about competition law. It just doesn't come up in most workers' day-to-day life. My guess is, by the way, of those 30 million workers, that a very sizable percentage of them don't even know that they're subject to a non-compete unless they have tried to leave their employment and go to another job. It's only at the crisis point
It can be a
that they
really
find out
nasty
about it.
surprise.
Right? Because it's buried in that stack of documents that we all get at the beginning of our employment. And they just say, sign here, and you think it's like, okay, direct deposit, and this is my health insurance, and this is my retirement, and oh, what am I signing here? And, you're signing away the rights to one kidney and your opportunity to quit your job. So most people, though, they just don't think about it. It is not a salient fact in their lives. But for many years, people like you and others in antitrust world this is not true of you, but people who talk about antitrust and teach antitrust tend to focus on competitive barriers in the consumer market, right? Rather than in labor markets. So an example of that, just to randomly pick an example, is if a tech company were to force users of a particular smartphone to buy their apps in that smartphone company's app store and then take a cut of the money that the app developers get from the sale of those apps. I'm not pointing any fingers. I'm just saying that would be an illustration of an anti-competitive or seemingly anti-competitive practice in a consumer market. Consumers are buying
Product
a
and
good,
service,
their
yes.
price is too high because there's an anti-competitive barrier in the way. Okay. That's how antitrust has been thought about. I think you tell me if I'm wrong, I think for decades. Now, under the leadership of Chair Khan, the FTC is suddenly injecting itself into labor markets. And maybe there's a precedent. You'll tell me if you know of a precedent. Does the commission have the authority to intervene in labor markets?
Yeah, so I think it's actually not, it's perhaps an area of law that hasn't been focused on in this sort of interim period of, there was decades of retrenchment from enforcement of the antitrust laws along a number of dimensions. But, the fact that, monopsony has always been an appropriate subject of the antitrust laws, labor market competition being, the most common example. I think of, for example, like the Packers and Stockyards Act is like fundamentally a labor monopsony statute in many ways. But the Sherman Act, there's plenty of early legislative history that reflects a real concern about labor market competition as well. But you're absolutely right that we've been revitalizing this area of law under Chair Khan. The merger guidelines that the Department of Justice and FTC put out, for example, emphasize that lack of competition in a labor market can be a basis for stopping a merger. The commission just recently challenged the Kroger-Albertsons merger, including a labor market competition count in that complaint. And our unfair methods of competition authority here is, quite clear in the statutory text that we have this authority. Again, hasn't, went through a period of retrenchment, but it is an authority that was used, not necessarily in labor markets, but, the commission did, some 20 odd legislative rules under our unfair method of competition rulemaking authority over a period of decades. And so it is a authority that we are using that rests on a very firm foundation here.
So despite that view, you're going to get sued. Not you personally, but the FTC is going to get sued. In fact, our friends, actually not that far, just down the street from the FTC at the U.S. Chamber of Commerce, have already announced that they are going to sue to block the FTC's non-compete rule. My guess is that lots and lots and lots of law firms that have dollar signs in their eyes are pitching to their trade association clients and their employer clients that they should sue, and maybe there'll be multiple lawsuits against the FTC. Now, when you of course, you put this proposed rule out for notice and comment. You got 26,000, I think, tell me if I've got this
over
right,
26,000
comments, which is a pretty robust public comment process. On 26,000 comments on the proposed rule, I should say. I got one quick question. What percentage of those comments were in favor of the rule and what percentage were against?
Over 25,000 of those comments supported a categorical ban on non-compete, Seth.
Yeah. If only this were a vote, right? But if it's not. But you got at least 1,000 anti-comments, and maybe you got some sort of in the middle where people were saying, well, do this, but don't do that. And there's a way to do this right. And what are the arguments that your opponents are going to bring to court, and maybe to the court of public opinion, to undermine the rule, get a court to block the rule over the course of the next several months?
Yeah. So one thing I want to note at the outset that I thought was the commission did this in an open commission meeting yesterday out in the sunshine and transparency, and all of the commissioners had an opportunity to give remarks on their thoughts of the rule, including our new colleagues at the commission. Our 2 Republican commissioners were recently confirmed, and so we are back at full strength at the FTC. I thought one of the things that was quite notable about their remarks was that they focused on the legal authority questions, but both of them raised concerns with non-competes as a policy matter. They thought the FTC wasn't, the right institution. I've been still for too long. But did as a matter of competition policy think that non-competes can be concerning. So I think we will see are seeing lawsuits focused on whether we have the legal authority. The plain text of the FTC Act is quite clear here. It says that the commission is empowered and directed to prevent unfair methods of competition. And it says that the commission has authority to issue rules and regulations to carry out the purposes of the act. It's hard to get clearer than that in the plain text. But Congress did get clearer than that in the plain text. That's what the FTC Act of 1914 said. The commission then, as I said, issued quite a number of substantive legislative rules using that authority. Some of them were very high profile. The cigarette rule, for example, which prompted disclosures about the health risks of cigarettes on cigarette packs, was issued originally under this authority. The DC Circuit and the Seventh Circuit each had occasion to consider whether we had this authority and challenges to rules that were issued under it. Both of them held that we did have this authority. And Congress then passed 2 amendments to the FTC Act in the course of making other changes to the FTC Act, which make express reference to us having this authority after these high-profile rulemakings happened. So, we have plain text from the outset. We have some fairly high-profile rules by the commission, and then we have Congress reaffirming the authority, again, expressly in statutory text.
Okay, so I'm gonna do a little legal wonk out with you here now. So taking all of that as true, there's a new legal doctrine invented with no justification in the United States Constitution, let's just say, but invented by the Roberts Court. Some members of the court are big advocates of this doctrine. They have used it a number of times to knock down regulations. It's called the Major Questions Doctrine. I know you are very, very familiar with it, and the logic. I'm gonna use the word logic, even though I think it is a laughably illogical doctrine, made up legal doctrine. It is that if Congress wanted a regulatory agency to take on a very, very big issue, like requiring vaccines for all workers in workplaces that are covered by the Occupational Safety and Health Act, which is actually a case that the court heard, or gigantic environmental regulations. If Congress wanted the regulatory agency to take that action, they would have specifically said so in the statute, or they would have specifically authorized the agency to act in that topic area or something like that. I'm giving it more shape than it actually has. Right now, it's just a bludgeon that the court uses whenever it feels like it and decides politically that it wants to go after a regulation. Is this rule vulnerable to a major questions doctrine challenge, do you think?
I'm sure we will see those challenges brought by the industry folks who have been quite clear that they intend to challenge this rule and have been clear, said that even before the rule came out, said that they would be suing no matter what. That said, I think, as I said, this rule rests on firm legal footing. The major questions doctrine, focuses on when an agency is cutting out and doing something new. This is an area where the FTC has been, has a huge amount of expertise. Addressing non-competes is right at the heartland of our mandate to address unfair methods of competition. Hard to imagine something more squarely at the heart of addressing unfair methods of competition. That's something where they're telling you right in the name, the point of this is to prevent competition. And our rulemaking authority, by definition, the FTC is tasked with addressing unfair competition methods across industries. Right, we're not a single jurisdiction agency in the way that some are, and so it's not like we are, reaching out beyond the particular industry that we oversee. We've been tasked with addressing unfair methods of competition in or affecting commerce. And that's precisely what this rule does.
Yeah, I certainly hope the courts buy it. And when I say the courts, I mean the courts in Texas where this case is going to be brought, and then the U.S. Court of Appeals for the Fifth Circuit where it's going to be appealed, because that's where the business community brings all of its anti-regulatory lawsuits, because they think they have the judges there locked up, and I'm not so sure they're not wrong about that. I'm not going to ask you to comment on that. Now that I'm out of government, I can say things like that, and I don't get in trouble anymore. Okay, so I want to ask you one question, sort of get away from the arcana of the law and just to focus on people a little bit more. So you've mentioned a couple of examples, an asphalt company employee, for example. What were you've seen so much material and so many comments submitted by ordinary Americans to the FTC talking about their experiences with non-compete agreements. Give us and again, I want to repeat what I said before, is that most people think this is highly skilled, highly paid workers, CEOs, scientists, tech workers who are doing specialized work, who, the employer, maybe there's an argument that they should be locked into their job, although I don't think that argument is a very successful one. But that's not who's affected by this. Tell us some of the folks that you've encountered in the comments or from public hearings or just from public commentary who are affected by non-competes, who maybe are not the way most Americans think about them.
Yeah, that's right. And I want to start by expressing my gratitude to the tens of thousands of Americans who participated in this process and brought their stories to the commission. The staff at the commission reviewed every single one of those comments and grappled with them and took them seriously, and it matters. And so I just want to say thank you to people who took the time to share their stories. You're absolutely right that what we found is that these may have started in the boardroom, but they have proliferated across occupations, across wage levels. We heard from every corner of the country. One comment that jumped out to me that I think will always stick with me is the comment of a bartender who said she was sexually harassed. And after she was sexually harassed, she quit her job, only to learn that she was subject to a non-compete, which she didn't know about prior to that. And the employer sued her for $30,000, over a bartender leaving for another job. It's really, really remarkable. Lots of comments from the medical community So, we see lots of doctors, a doctor from rural Appalachia who talked about how a non-compete contributed to healthcare access issues, because when you're forced to move out of an area by a non-compete, your patients are left behind and without care. Lots of stories about the fear that comes from a non-compete and the ways in which it causes people to hold back from protecting not just their general power in the workplace being eroded and in the market, but also their ability to report safety violations and violations of the employment and labor laws, when that they can turn around and essentially force you out of your profession or out of your state. Janitors, people in the fast food industry, hairdressers, the full gamut.
Yeah, I saw a story about a nail stylist, and perhaps there are arguments for CEOs, and I understand that you all excluded CEOs and other C-suite folks from this job. There is simply no argument for a non-compete covering a hairstylist, a nail stylist, somebody who's working in a fast food restaurant. There's no legitimate argument other than an employer using their power to force a worker into lower wages and to keep them from quitting to find a better job in the same industry. It's just pretty disgusting.
Public professionals, would you like to learn how data, digital innovation, and AI skills can improve your work and help you serve your constituents better? The answer is Innovate US. Innovate US offers no-cost learning on the skills you need to succeed in government in the 21st century. Attend a 1-hour weekly workshop or enroll in a course on AI or human-centered design at your own pace. It's all free to you. Visit innovate-us.org today to learn more and sign up. That's Innovate-US. Visit right now.
Let's take as the premise for this next question that the rule survives the legal challenges we were talking about. Let's take as the premise that it comes out intact and it is the rule that you and the commissioners and your staff wrote, as I certainly hope it will be. How is it going to be enforced? Is the commission going to have to enforce it in every case? Or will individual workers be able to bring private rights of action against their employers if the employers violate the rule?
So the FTC Act does not include a private right of action. That said, when a rule is promulgated under appropriate authority, as we think it is, it can preempt and does preempt conflicting law, including state common law, and the rule renders unenforceable non-competes. So it may be the case that we see, if an employer tries to enforce a non-compete agreement, you may see workers may be able to raise as a defense to that action that it is preempted by the rule. We may see that as enforcement mechanism. The rule is also very clear in its preemption clause that states can continue to enforce laws that are not in conflict with the FTC Act. And it takes care to explain what that means in this context because, for example, some states have bans on non-competes, but they're limited to some narrower class of workers. They can continue to enforce those laws, which is important because they sometimes have additional penalties. They may have private rights of action under their laws and so forth. That's not a direct conflict with our law. What a state simply can't do is authorize a non-compete that the rule prohibits.
All right. So I want to I want to say what you said, but I'm going to sort of turn it around a little bit. So if you're a worker and you're subject to a contract that has a non-compete clause in it, once this rule takes effect, you can quit your job. And if your employer tries to sue you or take any action against you, you should win in court, even if you're in a state court or a local court, because the FTC rule governs and states are not allowed to have their own rules allowing non-competes. So those contracts will be, at least that part of the contract will be null and void. And correct me if I'm wrong, as I know you will, wouldn't be the first time, that the rule doesn't just apply to literal non-competes. There doesn't have to be a heading in the contract that says non-compete clause. It's also other provisions that would operate like a non-compete clause. Do I have that right? And give us some examples of what that means.
Yeah, you do. And I want to add another dimension to this, which is it doesn't have to be in a formal binding contract. If it is in your employment handbook or some policy or thing like that, even if it is not an employment contract. Of course, as you know, lots of people don't have formal employment contracts. Right. Those are also covered. The definition of non-competes covers provisions that, by their terms, prohibit you from seeking or accepting other employment or starting another business after the conclusion of your employment. It also addresses clauses or provisions that penalize you from doing that. So if it says, you have to pay money, if pay as liquidated damages if you go work for a competitor, that is also covered. And then it also has a third prong, and these are all or conditions. Any one of these suffices if it functions to prevent you from seeking another employment or starting your own business. That is also covered. So that can be the sort of thing like we're seeing training repayment agreement provisions would be analyzed under that third prong for if they are so onerous that they are blocking you from going to another job or starting your own business.
Right. There's an excellent reason why those are called traps, because that's literally what they are. They trap you just like a non-compete agreement traps you. So I want to deal with this enforcement issue sort of in a connected way. So these provisions will no longer be legally enforceable in any court, so employers won't be able to use them. But there is some experience from the states that have banned non-competes that some employers continue to include the non-compete clauses in their contracts as little more than an effort to intimidate their employees. So, maybe a supervisor points to it and says, oh, look at what you agreed to. Even, and of course the supervisor doesn't finish that sentence by saying, but of course that's not enforceable in court. Even in states where it is not enforceable in court, like California, for example, has a non-compete mostly ban. What's the remedy for a situation like that where workers don't read the Federal Trade Commission Act or the Federal Code of Federal Regulations or the Federal Register? They don't necessarily know all of this stuff. They do have, in some limited number of cases, they have unions to help them. They have advocacy organizations to help them. How is the commission going to deal with situations like that? And how are you going to prevent situations like that where the employer is just taking advantage of the lack of knowledge of their employees to treat them as though they're still subject to non-competes?
Yeah, so the commission did two things to address this. One is prohibiting not only enforcement, but attempted enforcement, and representations about whether that you're subject to a non-compete when you are not subject to a non-enforceable non-compete. So the prohibition is not just on the having the non-compete itself, but also these what we refer to as interim uses of non-competes is prohibited. And then the second thing that the commission did is require employers to give workers notice that your non-compete is not enforceable after the effective date. So when the rule comes into effect, employers, other than with respect to senior executives, but for all that vast majority of other workers, they will get a notice from their employer that says, I will not be enforcing your non-compete going forward.
Let's hope that's enough. I hope it is. My hope is that workers out there will call their local legal aid society or call their local labor union and, maybe invite them to organize their workplace, but find out the facts, ask an employment lawyer. It's not that expensive. A lot of employment lawyers will do it, I suspect, pro bono. Folks want this to come out right. And I think the commission did come out in the right place. And I really congratulate you, Hannah, on the outstanding job that I knew you would do in working with your colleagues at the commission to get this rule out the door. This was a hard lift. This was a heavy lift and a hard lift, and you did a great job. And I really appreciate you being here. Our strategy for these blogcasts is to bring very, very smart people on and then just get out of their way And it's just a bonus for me that I get to bring my friends on and talk to them about things that we both really care about. So Hannah Garden-Monheit, she's the director of the Office of Policy Planning at the Federal Trade Commission, a good friend, one of the smartest people that I know. I very much look forward to her being sworn into the U.S. Court of Appeals for the District of Columbia sometime during my lifetime. She's laughing, but I suspect there are people talking about it, and I'm really grateful to you for making a stop here at the Power at Work blog before you go on to greatness. I was going to ask you what's coming next, but my guess is maybe a little rest, maybe a little bit of a break is going to come next and getting ready for the lawsuits. And I want to thank our audience for joining us for this breaking news blogcast. You can leave your comments about this blogcast at the bottom of the page that the blogcast is embedded in. If you have something you want to pass along to Hannah, post it in the comments and we will pass it along for you. We're also available to you on a lot of social media channels. We have pages on LinkedIn and Facebook. Just search Power at Work blog. You can find us on Power at Work blog on Twitter, X, and Threads. You can find us at Power at Work on Instagram and TikTok as well. You can find all of our blogcasts on YouTube, on the Burns Center for Social Change channel, also here on the blog, and all of our blogcasts are available on all of the commercial podcast providers. Just search Power at Work. Go to Spotify, go to Apple Podcasts, go to Overcast. We are there. You can download and listen to Hannah in your car. Please don't watch this blogcast in your car. It's not safe. We want you to download it and listen to it instead, because there's a lot of wisdom here and I think a really terrific conversation. Hannah, thanks again to you. Thanks again to the audience. We look forward to seeing you all back here on the blog very soon.
The Power at Work blog is a project of the Burns Center for Social Change at Northeastern University. The Burns Center develops innovative, participatory, and equitable approaches to solving public problems using new technology. Our faculty and fellows are accomplished, nationally recognized changemakers. Interested in learning more? Go to burns.northeastern.edu and sign up for our mailing list. And you can follow us on social media at Burns Center on Twitter, LinkedIn, and Instagram. The Burns Center for Social Change, from demanding change to making it.